We're into termination for default. This is the third type of termination. This is the first slide, right? A contract should be terminated for default only after. Did I?
Yeah.
All right, okay.
Yeah.
Just want to make sure I'm not ahead of myself, which I never am because I'm always behind. That's why I'm not a stand-up comedian. I never wouldn't make it. Should be terminated for default only after 1, all other reasonable remedies have been exhausted, such as remediation plans and liquidated damages and various things of that nature, and it is determined that it would not be in the state's best interest to continue the contract. So we've tried, haven't gotten everything we wanted, and we're deciding the best thing is not just to live with whatever we're getting. The best thing is to simply get out of the contract. A termination for default allows the state to terminate the contract in whole or in part, so it doesn't have to be the whole thing. It can be just part of it, whenever the following 2 events occur. 1, the state determines that the contractor has failed to 1 or more of A, B, and C. Perform within the time specified, perform 1 or more of the provisions, or make progress so as to endanger performance. This is the one where they haven't actually missed a deliverable yet, but all indications are they're not going to get there. That all the available evidence is that by the time the date comes for actual required performance, they will not be performing. And so we may not want to wait until we get to the point where the performance is required to find out we don't have it. We may want to terminate the contract and go and try and get it in some other fashion. So this is the first circumstance that has to prevail. One of those 3. Second is if the contractor does not cure such failure within 10 days after receiving a notice from the procurement officer specifying such failure or a longer period specified by the procurement officer. Let me go back. The following 2 events occur. Number 1, there has been a failure to do something, and the contractor does not cure such failure. We put them on notice, and usually this notice right here is called a show cause notice. Show cause why we should not terminate the contract for default. And the clause, if you look at the mandatory clause, and there's actually 2 mandatory clauses. There's a short form and a long form. Most of the time we use the short form, but the short form references the long form. The short form is about that long, 1 big paragraph. The long form is about 2.5 to 3 pages. And one of the things they say is, in so many words, we're supposed to give a vendor at least 10 days to try to cure deficiencies. Now, the reality is there's sometimes you cannot give them 10 days, depending upon the severity of what is not being performed. But unless you have a really extraordinary circumstance, you will give them at least 10 days. So it's 10 days or longer if you give them more than 10 days to come back with a cure. How they're going to get back on track, how they're going to perform as required. If you do a termination for default, so you have those 2 circumstances have occurred, so that now you have triggered the conditions for which you can do a termination for default. The state must pay fair and equitable compensation for performance prior to the contractor's receipt of a termination notice. So note it says for performance prior to receipt, i.e. they must have done something properly. If they've done something properly prior to when they're told there's a termination, they can get paid fair and equitable compensation for what they've done properly. But the state may, from any fair and equitable compensation for what you pay up here, otherwise do the contractor take the following actions. Deduct the cost of actual damages. So even though you may be entitled to something for some circumstances, now from whatever you're entitled to, we're going to subtract whatever the damages are for your lack of performance, withhold an amount that the procurement officer determines is necessary to protect the state against loss because of outstanding liens or claims of former lien holders. So if we have to protect ourselves, if claims are going to come in from somebody else, we can deduct an amount of that nature also from whatever we think is due to you. The state may procure substitute performance upon terms and in whatever way the procurement officer determines is appropriate. The contractor is liable, and this is kind of like a joke. It's an inside joke. I will read it and then I will tell you the joke. The contractor is liable for the excess costs of substitute performance unless the contractor's failure to perform arises out of causes beyond the control and without the fault or negligence of the contractor. In so many words, this is called, we can affirmatively collect damages. We can go back against the vendor for the cost of reprocuring if we end up having to pay more to another vendor than we would have paid to the vendor who has defaulted. And I'm saying it's kind of like a joke because I know of one instance in 30 years when it's been done. So I'm sure there have been more than one instance, but I know of one instance when we've actually gone against a vendor for expenses of this nature. But we have the right to do it, and maybe you'll find the instance where we actually can collect other than the one that I've talked about. And the one I'm talking about is the Hitachi situation that we dealt with in planning, for those of you who took planning and learned of the Hitachi situation. See, you should have been in planning, then you know what Hitachi did and what we got. If it is subsequently determined that the contractor was not in default or that the default was excusable, the termination for default shall become a termination for convenience. Now here is an issue. We have the right to terminate for default. I've already said the vendor cannot contest a termination for convenience. A vendor can contest a termination for default. They can claim we either, one, did not have the grounds because they have not, it isn't that they didn't perform, or they can claim the reason for the non-performance was excusable. It wasn't their fault. And you can go to the Board of Contract Appeals, and the Board of Contract Appeals can find that the vendor is right, that they were improperly terminated for default. And if the board finds they were improperly terminated for default, it automatically becomes a termination for convenience. It isn't unterminated, it's just changed from default to convenience, and once it's changed to convenience, the vendor's entitled to incurred expenses. And if we would have time to go through the exercises that we have, there was one example that we would have given out to you about the Department of Natural Resources did a contract with a vendor to grow about 160,000 ducks or something like that. So they wanted to get ducks, and they wanted to release them so people could, for whatever you want to release ducks for, to go hunting or to help the environment or whatever. And they contracted with a vendor to produce thousands of ducks. And so the vendor went out and did all kind of things. They built a new place for, to incubate eggs, and they built cages, and they got in feed because they had to provide ducks that were like 6 months old or something like that. So the vendor spent thousands of dollars to get ready to provide this contract for however many thousands of ducks. And for some reason, the Department of Natural Resources terminated the contract for default. And the vendor filed a claim, and it was denied by Natural Resources, and the vendor appealed to the Board of Contract Appeals, and the Board of but before a decision was reached by the Board of Contract Appeals, Natural Resources agreed that they had improperly terminated for default, so it was automatically changed to a termination for convenience. And then the vendor wanted something like $90,000 or $80,000 or something like that of incurred expenses for the building and the incubators and the cages and all the things involved with trying to provide the ducks. And it was an interesting case of how the board decided what they were entitled to. But you're not going to see that because we don't have time. So remember, you heard about the MR ducks? Another weak attempt at humor. How to do a termination for default. The procurement officer should send the contractor a written notice of failure, otherwise called a shows cause letter, that states the following. And one of the things we were going to hand out, Mr. Pemberton, you had an example one time of a show cause letter. And we were going to get that and hand it out for this class. So if you can find that again, so people can. That states the following. 1, description of the failure. What did you not do? A description of what the contractor must do to cure the failure. Do what the contract calls for. 3, the amount of time that the contractor has to cure the failure, beginning with when the contractor receives the notice. So at least 10 days, but it could be more than 10 days from when they get the show cause notice. A warning that the contractor can be terminated for default if it does not cure the failure within the time period specified in the notice. So that's.
And a surety, we would copy the surety on the show cause letter.
If there's a surety, you will copy them so the surety knows what's going on. And if you had prior correspondence before this, the surety should have been copied all along. Let's see how to do this. If the contractor does not cure the failure, the procurement officer must send a written notice of termination. So back here, you have a notice of failure. We're putting them on notice that we are on track to terminate for default, depending upon these things. And then now, we're actually assuming they don't cure it. Now we're going to give them the actual default notification. We're actually going to default them. And this must state the extent to which the performance is terminated, in whole or in part. If it's just in part, you tell them it's in part. If it's a whole, you tell them the whole thing is terminated. The date or time when the termination becomes effective. If you remember, I talked about the one housekeeping contract when I told the story about the apple core that was behind the water fountain and was there for weeks.
Yes.
You had to be in the, I think that was in planning class. I don't remember what that was. No, that was this class. It was this class.
I think that was in the planning.
It was this class because it was performed. We modified the contract to bring in standards that we used then to default them. But because we had to do a procurement to get a new vendor, we told them it was going to be 2 weeks in the future before they were terminated. So they still had to perform and do just as good a job for the next 2 weeks that they'd been doing for the prior 2 years or whatever it was, which meant lousy. But you tell them when the termination becomes effective. You reference the clause in the contract that allows termination. You reference the termination for default clause and anything else that is appropriate to tell them. Disposition of furniture, disposition of inventory, final bills, anything we're going to withhold, anything else you need to tell them is in this termination letter. Okay, termination for default example. A small institutional pharmacy company in Baltimore won the contract to provide the pharmacy needs of the residents of a DHMH acute care facility in Salisbury, otherwise known as the Deer's Head Center. On the first day of the contract, there were about 20 pharmacy errors by this contractor. Pharmacy errors could be minor, such as being short a pill, or major, such as you gave them the wrong pill, or you gave them the wrong strength, something of that nature. So anything that was not exactly as it should have been was an error. And so the first day there were 20 errors, and under the previous contract there were an average of 4 errors per month. So you go from 4 a month to 20 the first day. Despite emergency meetings with the vendor on the second and third days of the contract and concerted effort by the contractor, and I will emphasize concerted effort by the contractor, the error rates continued at this level for the second, third, and fourth day of the contract. What would you do? 20 errors a day. What would you do? Yes? Send them a cure letter. Give them, how much time would you give them to cure? 10 days. 10 days. You got that right. Okay, what would you do?
You gotta document it.
Document the errors that were taking place?
All of that.
Yes, okay. Check the drugs? You mean you'd try and make sure the patients didn't get wrong drugs? Okay, yeah, that happened, and we'll mention that. Flat out terminate. No 10 days? Off with your head? This is too important to give them 10 more days? Medicine's important, so you think this is kind of something you may not wait 10 days?
Depends on what kind of errors.
Depends on what kind of errors, yeah.
Are you allowed on a contract like this to award multiple vendors so that you have a backup in the?
Could you award multiple vendors? Probably could, but in this instance, we didn't, because then how would you decide which would go to one vendor versus another? But to a degree, we're going to get to what you said, to a degree. Yes?
Could you terminate for convenience and then hire the second bidder?
Why would you terminate for convenience?
Well, it's only 3 or 4 days into the contract. Just
Okay.
terminate for convenience and then hire the second bidder.
Was there an error rate in the specs? 'Cause
I don't know that there was
I
an
don't know if
error
he's
rate.
defaulted. We may accept 20 errors a day, I don't know. But that's not in the spec.
As long as you're gonna have one of the 20.
One at 20.
If I remember, they couldn't have any major errors.
And they're automatically in a default mode.
Medication errors are pretty serious things. For default? You mean, that's what you're agreeing with him, that maybe, it depends on how rigid this 10 days is, that if you can't do 10, but you can't live with it.
9 days, and then send you drugs.
Yeah.
And that's not
Okay.
involved in the newspaper because Joe Blow, the patient, died because he got the wrong medication.
This is serious stuff.
Liability is very high here.
Yeah, all right, let's see here. What would you do? Something needs to happen. Agency personnel worked with the contractor extensively over 3 days to try to minimize errors. Agency personnel, to take your statement, inspected all prescriptions delivered to ensure residents were not given wrong medication or doses. The contractor was put on notice on the second day that continuation of such a high error rate would lead to a prompt default declaration. The previous contractor was contacted to see if it could and would resume the contract if needed. The previous contractor said it could resume services on less than 24 hours' notice because it was in Salisbury. It had been off the job for 3 days. It's there already. It's not as if they have to do something drastic to simply resume what they've been doing for years. On the 4th day, the error rate did not decline. What was that? Well, there's more to this. The procurement officer terminated the contract for default that afternoon. And I didn't like doing it. Despite the normal requirement for 10 days notice, the determination of all parties was this was too severe that we couldn't wait 10 days. So we simply terminated, and we did a 6-month emergency contract with the previous contractor, the minimum duration that they said they wanted. And that's, again, to illustrate who's in the driver's seat. We go back to the vendor. Will you do like a 2 or 3 month contract? Nope, 6 months or nothing. So we enter into a contract with the vendor because we need them. I don't even know what we paid them, probably more than what we were paying them before, I don't know. But that's the situation if you're going to them and begging them to do something for you. It was decided the issue was, did we need to change anything in the specifications now that we had this instance? Should something be changed in the future? We were going to continue for 6 months with the previous vendor. We're going to do a new procurement. Did we need to do something different? And what we decided, the only thing that needed to be changed in the specifications was a specific statement that if the prime contractor was located more than 1 hour normal drive time from the facility, that they had to use a subcontractor. So needed a subcontractor pharmacy to be used if the prime contractor was located more than 1 hour, because there was a 1 hour stat requirement that they had to have the ability to deliver an emergency medication within 1 hour of notification. And if you are the selected vendor and you're located in Baltimore, you're obviously not within 1 hour. And so because we don't want to be at the mercy of you perhaps not being able to do that, as part of the specifications and part of the bid review, they had to identify a subcontractor that was located within 1 hour. That subcontractor had to acknowledge that they were a subcontractor to this prime. They were aware of the requirement for 1 hour notification. They were ready, willing, and able to provide medications as needed. And they had to provide references that indicated they were currently doing 24-hour-a-day delivery, including within 1 hour, all of that to evidence that there would be the capability if there were problems. So that was the change. Set in the specifications, the references would be checked, both for the prime and particularly for the subcontractor if they were going to be used to meet the 1 hour stat requirements. The language developed from the laboratory was developed from the laboratory contract we talked about on the first or second day, if you remember that. The one for Spring Grove, where the vendor, when they needed them at 2 o'clock on the Sunday morning, they called and there was no answer. And then they went and complained to the vendor, and the vendor said, okay, you need to call the DC lab and they'll come and pick it up. So we had another occasion, they called the DC lab, phone got answered, and the vendor said, I don't know anything about Baltimore. I don't know, I've never heard of Spring Grove. I'm not coming to Baltimore to pick up anything. So that type of scenario, what we described back 600 slides ago, is what we used as the template for this particular one. And what we focused on was these situations, which I guess, as I said, you always kind of like live and learn. That if there's no problem, you don't go trying to address a problem that you've never had before. We never had anyone other than vendors from Salisbury bid on this contract. And so it was kind of like a shock that you had a vendor from Baltimore that was bidding on the Salisbury contract. And it was a bid, so it was a low bid. And in retrospect, could we have done more to make sure the vendor was capable of doing the job? Yep, in retrospect, we could have and should have. But at that time, it's you open the bid, they're low bid, they're a pharmacy company, they do pharmacy work. What's the problem? They just have to go further than the one that's located a mile away from the facility. Let's see. And what became a critical issue here is this particular facility was known as an acute care facility. Acute care facility means that the prescription might change not only day by day, but sometimes even over the course of several hours, versus a chronic facility that basically a resident is probably going to have the same drug for 30 days and then for the next 30 days. So there's very little change in the requirements of residents at a chronic facility versus an acute facility. So we became acutely aware of the differences between acute facilities.
Amen.
You got that? And the factor of distance. One thing if you're in Salisbury, completely another thing if you're in Baltimore, and the size of the vendor. This was a small vendor, and even though the pharmacy that had been doing it previously was a small vendor, it was a vendor in Salisbury versus a vendor in Baltimore. And the whole issue here, and the reason why I said that I felt bad terminating, this vendor really tried, and I know it sounds bad to say they went from 4 errors a month to 20 a day, and it sounds like they were doing a horrible job, but the vendor was really trying to do a proper job. And within even 3 days, what we found out and what they found out was that they would get the first day's order. So maybe something was faxed in by 3 o'clock for delivery, let's say 10 the next morning, something like that. So they'd get the order, they would spend a couple hours filling all the orders, getting the unit doses ready to come and deliver it to the facility. And then once they spent a couple hours getting all the drugs together, then someone hopped in a van and drove 3 hours or so to get to the facility. And then they would distribute it throughout the facility to where it was necessary. Then they get back in the van and drive back to Baltimore. And by the time they got back to Baltimore, it was time to get the next days together. And since they weren't a big facility, they sort of had some of the same people who were doing the pulling of the drugs, the driving, the taking, and coming back, had to do everything. And they were burning the candle on both ends. And even though they were conscientious, they weren't getting things done. And another thing that it turned out is there was a lack of communication between facility personnel and the vendor. And what happened, and this happened in retrospect because I remember the one meeting that I had with the vendor and with the personnel from the facility, and the vendor's talking about all the efforts they're going through, and the facility is saying, but you're not doing this, you're not doing that. And the vendor's saying, well, you know, it would have been nice if we would have had ability to like tour the facility in advance. It would have been nice if we would have had the ability to sit down and get some direction and find out some specific things rather than find them out after we were told they're wrong. They were kind of saying, in so many words, we wish we would have had a very good work initiation conference before starting. They did have what I would call a very cursory work initiation conference, but the bottom line was the facility personnel kind of, if I can put it this way, resented the fact that this vendor from Baltimore had, number one, bid on the contract, and number two, had been the low bidder and had won. And so, not that they went out of their way to prevent the vendor from performing, but they certainly didn't go out of their way to help the vendor. They didn't do the kind of things that we've been advocating in this class, that you have them come in, you take them around, you acquaint them with people, you let them know any of the idiosyncrasies of the facility before service delivery has to start, so that for the most part you've tried to work out issues. And the only thing that happened was one very cursory work initiation conference where seemingly, and the facility people kind of admitted this afterwards, when the vendor brought it up kind of gingerly, because they were trying to offer some excuses for their poor performance, and they threw out a couple things, and what they basically said is, we went to this meeting, we started asking questions, and in so many words, we immediately got the sense that you were resentful of us, and you felt that we were showing a lack of knowledge by even asking questions, and within a very short period of time, we got the notion that you didn't want to help us, you didn't want to cooperate, you basically wanted us to go away, and so the meeting probably ended after 20 minutes or 30 minutes without much being accomplished, other than both sides expressing, well, the one side expressing irritation to the other side, and the other side getting the notion that don't ask, just try to do the job and muddle through as best you can, which is not a formula for success. And once I learned these details by being there with both sides and being in the room and having the back and forth between the facility personnel and the vendor personnel, and the facility people actually kind of apologized to the vendor for their lack of cooperation, which was nice after the contract's terminated for default. But that part of this was stemmed from two factors: that lack of a cooperative effort in the beginning between the facility and the vendor, and our lack of understanding of some of the issues involved, and our lack of making sure, as much as we could, that the vendor had capability. And so the bottom line for all this was that even though on the fourth day I terminated for convenience, And let me get to this. Given the size and location of the Baltimore firm, it was possible that it was likely to fail under this contract no matter what facility personnel did or didn't do. But the failure likely wouldn't have been so soon or so stark. Or maybe the vendor might have sensed it was unable to perform before it started service and asked to be let out of the contract if there was a good work initiation conference. So for their part, facility personnel worked diligently with the vendor for 3 days and regretted their lack of outreach and support before the contract started. And here's the important thing. I did not deem the vendor, even though I defaulted that vendor for default. I defaulted the vendor for default after 4 days. I came, after those meetings, I didn't have the conclusion that that meant that vendor was neither unwilling nor not capable of performing that same type of service other than in Salisbury. It's like, okay, it's not that they can't do it, they just can't do it 100 and some miles away. So, as circumstance would have it, less than 6 months later, this vendor bid on and was awarded a contract for the Rosewood facility, Rosewood Center. And they bid on Rosewood, and I could have said, nope, you defaulted on Deer's Head, so you're not a responsible vendor. We won't accept a bid from you. They bid on Rosewood, and because I actually was impressed by the personnel and their conscientiousness and the extenuating circumstances, I determined they were responsible for providing services at Rosewood because of several circumstances. Number one, it was in their backyard. I think the vendor was located in Knowings Mills. So now they had the opposite situation of Salisbury. It was in their backyard. Number two, Rosewood had on-site pharmacists. So there was already someone there to help the delivery and to do many things. And number three, Rosewood was a chronic care facility, not an acute care facility, so it was a much more stable population and drug demand. So I determined it was completely different circumstances, and under those circumstances, I felt the vendor was capable of doing the job, so I awarded it to them, and they did a good job. So that just illustrates you default one place under one set of circumstances, and it may or may not mean a vendor's not capable somewhere else under other circumstances. In the end, this episode was a valuable learning experience for all parties, including the procurement officer. As I've said many times, the reason why I know what I know is because I've made so many mistakes along the way, and I try not to make the same mistake twice. I'm a slow learner, yes. That's why I keep telling you all the mistakes I've made. Well, just a small fraction. Let's see. Any questions on termination for default? Okay. Anticipatory breach of a contract, including misspelling breach. Okay. See, we're faking you out by not even spelling it right. It's B-R-E-A-C-H. Occurs when a contractor declares or implies by specific and unconditional word or action that it does not intend to perform its contractual obligations. So they have not defaulted yet. They have not failed to perform yet, but by specific and unconditional word or action, it is communicating it does not intend to perform what the contract requires. A mere request for a change in terms or a request for a cancellation of the contract is not in itself enough to constitute a repudiation of the contractual requirements, and there is no anticipatory breach, spelled correctly, where the professed inability to perform can be overcome and the contractor expresses a willingness to continue to perform. So if they don't give you a specific and unconditional notification they don't intend to perform, and they instead can and are willing to, you do not have an anticipatory breach. And you're asking, why am I telling you this? Because, I'll tell you why I'm telling you this. Upon an anticipatory default declaration, the contracting agency may take immediate action as if the default had already occurred. You don't need to wait for the default because you now know the freight train is coming down the track, so you know to do something to try to prevent it from jumping the tracks or whatever to try to prevent bad things from happening. And here's a hypothetical example, and I will emphasize hypothetical because this has not happened. I don't know if it's likely to happen, but I just invented it. So, and when we do this for public safety, we don't want them to get all excited because we're saying something happened. A vendor that operates a residential treatment facility for women drug addicts that have been convicted of minor crimes and that have dependent minor children who reside in the facility while their mothers receive treatment sends a letter to the contracting agency that is going out of business and will close the facility as of noon 2 days later and will put the residents and their children out on the street at that time. So if you have this scenario where you have women and children in a location and you get a letter that is signed by the president of the company or someone in a position of authority that says, come and get them because in 2 days we're closing the door, we're putting the padlock on it, and they're out on the street. And you either come and get them or you pick them up on the street. If that's something you get, now maybe you'll make a phone call to actually say, are you really going to do this? But if you have the clear indication this is going to happen, that is that specific and unconditional notification, then you don't have to wait until the person actually puts the people out on the street. You can go and take action as if the default had already occurred. To the extent that the agency can reliably expect this contractor to follow through with what it says it will do, instead of waiting until 2 days later at noon to see if the residents and their children are actually forced to vacate the facility and fend for themselves on the outside, the agency can take action to remove the residents and children before then, as if the eviction action had already happened. So that's an illustration of anticipatory breach. So it doesn't happen often, but it can happen. And I have one instance where I can't remember the details, but I did have one instance where I went, and this was many years ago, when I'd never even heard of the term anticipatory breach. And we got some kind of notice from a vendor, and I went to my assistant AG, and we were discussing with the program what to do. And my assistant AG said, well, you have an anticipatory breach here. And I'm like, who, what, where? Anticipatory breach. And I'm saying, what's an anticipatory breach? And well, I can kind of figure, well, anticipated breach. Oh, do you have such a thing? And I learned there was such a thing. And now I'm telling you there's such a thing of anticipatory breach. Questions? Okay. Void contract. A contract is void if the Board of Public Works determines that a procurement violates the requirements of Title 21. Having a contract determined to be void means the contract is terminated because it is belatedly realized that it shouldn't have been awarded in the first place. This is not a termination for either convenience or default. It's, if you can do the analogy, it's like a marriage being annulled rather than a divorce occurring. If it's annulled, it's as if it never happened to begin with. So if you have a void contract, we went back to the issue of legal capacity to enter into contracts, and a void contract means that for some reason there's not the legal capacity to have entered into the contract, which means you don't have a contract. The board, meaning the Board of Public Works, has delegated to an appropriate control agency, either DBM, DGS, do it, or the Treasurer's Office, or to MDOT or the Port Commission, the authority to make a preliminary determination as to whether a contract under this jurisdiction should be declared void. So preliminarily, we can, for instance, say we think a contract is void, but only, and if we don't make a preliminary determination of void, that means it doesn't go to the board. But if we make the preliminary determination as void, then it has to go to the board to make a final determination as to whether they agree it is void. And making a void determination means if the contract is declared void, the contractor shall be awarded compensation for actual expenses reasonably incurred under the contract, plus a reasonable profit if the contractor has acted in good faith, not directly contributed to the violation, had no knowledge of the violation before the contract was awarded. So if the contractor didn't know what was going on, didn't know something was being done incorrectly, and everything they did was in good faith, then even though the contract can be declared void because there was something improper that was done, they can be paid incurred expenses plus reasonable profit. Now you're saying, does that ever happen? Probably in a slide. Conversely, if a contract is declared void and the contractor contributed to the violation and or acted in bad faith and or had knowledge of the violation before the contract was awarded, it is not entitled to compensation for actual expenses reasonably occurred under the contract plus a reasonable profit. So if they were harmless, they can get things. If they're not harmless, if they contributed to it, they can't get those expenses and profit. If a contract is declared voidable versus void, it can be ratified by the Board of Public Works as essentially being an acceptable contract despite some defect in how it's procured. A voidable contract is not terminated. It is an action that occurs in the procure stage, not the perform stage. The reason why we're talking voidable means we're overlooking the defect, and the Board of Public Works ratifies it as if there was no defect, and the contract simply goes on. Void happens in the perform stage when it's, nope, there wasn't a contract, so it's going to be over, and now the question is, do we pay the vendor something because they were innocent party, or we not pay them anything because there is no contract to continue? So now we have a situation. We have a couple situations. Number one, void contract. A vendor won a contract to provide courier services from the state branch laboratories on the Eastern Shore to the main state laboratory in Baltimore. After the fact, it was learned this vendor was going to form a new company to perform the contract. On the basis of the signed state contract, the vendor got a bank loan to lease 2 vans and cover startup costs. 1 to 2 weeks after the award had been made, about a month after the bid due date, the incumbent called to find out what happened. The incumbent was not at the bid opening. The incumbent never followed up. I think the incumbent just assumed they were going to win again. So after everything is signed, sealed, and delivered, the incumbent calls up and says, whatever happened to that bid? And the answer was, you lost. Which, of course, they didn't like. And they said, well, who won and what was their bid price? And when the incumbent was informed it had lost and who won the contract, the incumbent said that firm was not licensed by the Maryland Public Service Commission to do courier work, which at that time was a requirement. Maybe it still is, I don't know, but at that time it was a legal requirement that they had to be licensed by the PSC to do that work. And in the specifications, it was required that they have a PSC license to do the courier work. No one checked to see if the company was licensed before making the award. So what would you do?
Check that they do have a license.
You would do what again?
I would check to make sure that they have a license. I mean, I wouldn't go on the word of the incumbent.
Okay. Yeah, you would go ahead and check and make sure they weren't licensed.
Right, the word for it.
Yeah. So what would anyone do?
Check out the license.
You're going to check the license, so now you determine that no, they are not licensed by the Public Service Commission to do courier work. Pardon me?
You void the contract because they didn't.
Are you saying we've given you the answer here? Since it's a void example? That's what's called deductive reasoning. Well, duh. It's an example of a void contract, so it must have been voided. And that's the right answer. Give yourself a pat in the back for deductive reasoning. What would you do? What was done? The new company was called and told that the award was being rescinded because the firm was not licensed by the Public Service Commission. Although it wasn't realized at the time, because I certainly had no idea about any of these things I'm about to talk about, what happened was that the contract award was declared void since the vendor didn't have the legal capacity to contract for courier services. It did not have the legal authority to contract for that particular activity. It also wasn't realized that also the Board of Public Works can declare a contract void. I didn't know that. I didn't even know I did a void contract, let alone know who could do it or who couldn't do it. Complication. Excuse me, that was a complication indeed. When told the award was being rescinded, the vendor said it had already leased the vans. I've already gone to the bank. I've already gotten the loan. I've already leased the vans. How can you take the contract away from me now? Woe is me. Does this make a difference?
No digging, no laundry.
No ticking. That means no?
No.
Okay. What if the vendor files a claim for the expense of the vans?
Denied.
Do they have a valid basis? Do they incur expenses to lease the vans?
They don't exist, they don't have a license.
Does any culpability fall, excuse me,
Well, I'm assuming the license requirement was part of the RFP, right?
the license requirement was part of, it was a legal requirement, and it was acknowledged by the requirement of solicitation that they have that license.
They knew they were in violation to begin with.
So you're saying that was not something they could not have known?
Right,
That they were in violation of the law?
right.
So are you inferring that since they are not an innocent party, they're not entitled to any money? Give yourself a gold star. You have the right answer. Does any culpability fall on the state for failing to verify the Public Service Commission license, thereby allowing the vendor to incur expenses to perform the contract? And the answer is no. Short answer. Long answer, if the contract is declared void, there is no contract.
They may not be culpable, they didn't do the job.
Yes. They put the vendor in a situation where the vendor had difficulty. So obviously, it's not a good thing to not check things and not make proper awards. Let's see. The vendor can be awarded, so we've covered this, what we just said. The vendor can be awarded a compensation for actual expenses reasonably occurred under the contract plus a reasonable profit if the contractor has acted in good faith, did not directly contribute to the violation, had no knowledge of the violation before the contract was awarded. While the vendor likely has acted in good faith and apparently had no knowledge of the violation before the contract was awarded, it is difficult to conclude the vendor did not directly contribute to the violation.
What do you mean?
I didn't know, I didn't know, I didn't know. I didn't know what I didn't know.
Had no knowledge that they had to be licensed?
Apparently not. That's the whole issue. The vendor was claiming, I didn't even know.
That is.
And of course, I didn't read these specifications that said I had to be licensed. I missed that too. So it is difficult to conclude that the vendor did not directly contribute to the violation, and the vendor didn't abide by, because the vendor didn't abide by a legal requirement to be licensed by the PSC, so it caused the violation. It caused the violation. So it was not an innocent party. It did directly contribute. Accordingly, the vendor would not be entitled to expenses or profit, and fortunately for the vendor, in this instance, it was able to cancel the leases. And on the one hand, again, you feel sorry for the guy. He won a contract. He's feeling good that this can be the start of him starting to grow a company, and he can do this work, and if he does good work, he can go on from there. And after he goes through this, then we pull the rug out from under him and said, you should have known better, which he should have, but we contributed by not checking. Yes?
Why wasn't that a minimum requirement of the contract? I mean, I think it should have been, that should have been the first thing that the vendors saw when they opened the RFP, was that being a mandatory minimum requirement.
Okay, what you're doing is applying what we're trying to talk about today with, and this was around 30 years ago. Yes, your answer is, should we have put this up front? Should we have emphasized this? Should we have made this as clear as we possibly could? Yeah, we should have. And hopefully, if this were being done now, we would have made this a more prominent issue. We would have emphasized this at a pre-bid conference. We would have checked before we ever made an award,
Don't sign a contract.
because you learn by examples like this what goes wrong if you don't do everything right. So hopefully we would not be in a situation like this again, and I certainly never was.
What if that requirement cost him money?
What if that requirement cost him money?
Potentially ignored that requirement, that's the local situation.
If he actually had to pay money to get that license?
Yeah, I mean, what if that requirement affected his
allowed him to underbid the competition because they, in good faith, incurred the expense and he didn't.
That's right.
It's cheap.
Things like that happen.
But read the document.
So let's see. All the problems in this example for the agency and especially the vendor could have been avoided simply by the agency verifying the requirements in the IFB. And like in the next void contract example, under different circumstances, an agency's failure to do something, such as check for a license, might result in expenses and profit that the agency might have to pay, with the agency receiving no value. Ah, you're going to love this one. I loved going through this one. March 1st, 2007, an agency entered into a 2-year agreement to lease 2 used motorcycles, Harley-Davidson motorcycles.
Amen.
Vroom, vroom, vroom. And the agreement was for 24 even monthly payments being made that would total the fixed lease amount, with the right for the agency to purchase the motorcycles after 2 years for $1. So that's what we did a procurement to get this. After the agency had made 6 lease payments and paid a registration fee totaling $10,322, it was decided they didn't need the motorcycles anymore. After we paid $10,322. And many procedural and other errors were discovered. Although the 2 motorcycles were solicited as a single lease request, and the total lease amount would be $39,890, the procurement was done as a small procurement. All right, anybody have anything to say about that?
Small procurement level.
Small procurement level, which is?
25,000, isn't it?
Well, is $39,890 more than 25?
Absolutely.
It is, huh? Oh, you mean anyone could have noticed that? The agency mistakenly believed small procurement was...
It's like that mistakenly believing the license.
You mean it's one of those examples of that's my story and I'm sticking to it? Mistakenly believed small procurement was permissible since each motorcycle was being leased for less than $25,000. It was only, what, $19,000 for...
445.
Yeah, something like that. So it's less than $25,000 a piece. So I can use small procurement, right? Right? And cannot artificially subdivide. All right, so that's the first mistake. They used small procurement, and it wasn't a small procurement. Second mistake: the Board of Public Works has only delegated to DBM the authority to approve vehicle leases that both do not exceed $10,000 and don't exceed 6 months. This was a 2-year lease for almost $40,000, so it exceeded both those requirements, which means it had to go to the Board of Public Works for approval. And DBM has not delegated vehicle leasing authority in any amount to any agency, even one for $1 or more. So even if it would have been less than 10 or less than 6 months, it still wasn't something the agency could have approved itself. The leases in question, I said that. Yes.
In this case, isn't there a checks and balance that should have been picked up before the award was made?
Within the agency, that's kind of our thinking.
I mean, my reality, you put it into the computer system, I would have thought that would have already kicked it out and said, this isn't eligible for that. No?
Going into AdPix, there's nothing that's going to reject that. Whether they do it as a direct voucher, whether the AdPix doesn't know whether it's a small procurement. AdPix doesn't know whether there's a requirement that this has to go to the Board of Public Works. If you put it in, it's in there. Let's see. Despite making 6 lease payments, the agency had never obtained a title for either motorcycle or license plates, so had never moved them from the spot of original delivery. The vendor brought them in, took them off, whatever they used to bring them in, put them one place, and in 6 months they had never moved because they had no license plates and they weren't registered. So they weren't legal to be operated on the highways. So we've paid $10,300 and some, and the motorcycles have sat there for 6 months. In consideration of all the above, the agency decided the leases should be ended and claimed it was the lessor's fault. You bad lessor, it's your fault. And why did they think that? This was claimed to be the lessor's fault because it was located in Wisconsin,
What's that have to do with price of eggs?
was not registered to do business in Maryland because it's in Wisconsin. It doesn't think it's doing business in Maryland because it's not physically present in Maryland. Reportedly, the failure of the lessor to be registered in Maryland prevented the motorcycles from being titled. And supposedly the vendor had reportedly refused to pay the $350 required to become registered in Maryland, even though the amount necessary for registration was included in the total lease amount. So it was the lease amount plus $350 for registration, but the vendor refused to get registered, supposedly. No, they went through a dealer in Rockville. But the vendor that did the leasing was from Wisconsin. And the other thing that I don't think is on here is they got another bid, and the other vendor, who was much lower in price, refused to sign a contract with the agency because the agency's credit was no good. That was the reason given. And when I heard that, I'm like, wait a minute, an agency does not have an independent credit rating. It's the state of Maryland. And we have a AAA bond rating. The state of Maryland is a pretty reputable credit risk. So somebody isn't going to sign a contract because of the credit risk? That blew my mind also. However, going back to the issue at hand, although it was claimed the lessor refused to register to do business in Maryland, it turns out the vendor didn't know it should be so registered. And within days of learning of this requirement, paid the necessary fee and became registered. As soon as it found out there was an issue, it went through the process, it got registered. So because of all the improprieties of this situation, the agency was told it needed to submit an item for retroactive approval of the leases by the Board of Public Works as voidable contracts. So get them ratified. You did small procurement you shouldn't have. You didn't have the authority to enter into the leases. You have to come back and get the leases approved by the board retroactively. But the vendor, the agency didn't want the motorcycles anymore. If you get it ratified as being voidable, that means you want to continue it for the next year and a half. And they didn't. They wanted to give the motorcycles back. And if the board ratified the leases as voidable, they would have continued in effect for 2 years, and the agency would have to terminate the leases for convenience and be subject to incurred expenses.
Amen.
If, after it got it ratified as being voidable, then they terminated for convenience. And they didn't want to do that. They didn't want the possibility of incurred expenses. So the agency wanted to terminate the leases for default based upon the lessor not being registered in Maryland. The vendor has defaulted because they didn't register, even though as soon as they found out they needed to, they did register. But a contract cannot be terminated that doesn't exist. Like, duh. If you don't have a contract, you can't terminate a contract because you don't have a contract. So you don't have a termination for default. The agency had no authority to enter into the leases as per the discussion of express, apparent, and implied authority that we stated on the first day. So the leases can only be terminated if they were first approved by the board. Then if the board approved them, then they could be terminated.
Bureaucracy at its finest.
Yes, you see how this is just a fun little example. Otherwise, the state could repudiate the leases and seek recovery of all monies paid because the agency had no authority to enter into the leases to begin with. So if they wanted to terminate, they had to go to the board and get it approved as being voidable, and then they would be terminated for convenience. But the lessor didn't want to hear anything about not getting the full lease amount, let alone giving the $10,322 back. It felt it had fulfilled the terms of the lease, it provided the motorcycles it promised, and registered in Maryland when told to do so. The state would have had to file suit in Wisconsin to try and get the $10,322 back. That's why you must sign an agreement that says the laws of Maryland will prevail, and you cannot sign an agreement that says the laws of another state will prevail. In this case, we would have had to go to Wisconsin, hire an attorney to try to get the money back, which everyone said, that's ridiculous, $10,000 in attorney fees, that we'd never get the value back because we'd pay it in attorney's fees. Since a standard state contract was not signed that said the laws of Maryland would prevail, and the lease that was signed said it was effective under the laws of Wisconsin. Again, no-nos. It was impractical to even think about pursuing this issue in Wisconsin courts. The expense would have far exceeded $10,322, but the agency stopped paying after 6 months when the errors were discovered, so no more money was at the issue. They had possession of the motorcycles, which were worth more than $10,000, so they had some leverage on the lessor in that the lessor would have to file suit in Maryland to get the motorcycles back. So we have to go to Wisconsin to get the $10,000, but you have to go to Maryland to get the motorcycles. We have more value than you have at this point in time. 19 months after the leases were first signed, 13 months after the payment was stopped, 12 months after the lessor registered in Maryland, 11 months after negotiations were started with the lessor on resolution of the issue, and with extensive dialogue between the agency, DBM, and the Office of the Attorney General concerning the best solution, the final answer was to submit an item to the Board of Public Works for it to declare the leases void. They never happened. It was agreed that the lessor was relatively innocent of all the transgressions of this situation, so was entitled to reasonable expenses, profit, etc., which coincidentally, and this is a coincidence only, that was determined to be $10,322 to be their reasonable expenses and profit to that point in time. I don't know where they came up with that number, but it was what they came up with. So after great exertion of effort and $10,322 of wasted money on 10/15/08, the Board of Public Works approved the void contract request to end this sad affair 7 months after the motorcycles that in over a year had never been driven had been returned to the lessor. So this was a situation that just shows how you can get into quagmires, and if it's bad enough, in the bottom line, it may be that you never had a contract to begin with. So what is the moral of the story? And this is going to sound like a kind of obvious. Doing things right the first time is the best way to avoid problems and minimize expenses to the state. Go figure. So, with that, I guess we're done for the day.